Okay. Ladies and gentlemen, good afternoon. Bob Clifford here in Chicago. On behalf of the lawyers and staff at Clifford Law Offices and my alma mater, DePaul University, I welcome you to the 8th of our conflicts and ethics seminars that we've conducted. This year we have the ethics of conflicts of interest. And we have a wonderful panel that I'll introduce momentarily. I think it's fair to say that those of us here in Chicago who are here live made a considerable effort to be here. It's last I saw, it's -7 on the dial and -30 windshield. So thank you all for being the troopers that you are. As is fairly well known, I think, in the legal community here in Chicago and elsewhere, the lawyers in my firm are committed to attempting to raise the quality of the practice of law in our state and our national practice. We take very seriously the notion that we are part of a noble profession that has an obligation to advance the best interests of our clients, and we think that we do that when we promote topics such as this, when we promote civility and when we promote continuing legal education by lawyers. This particular program, the Ethics of Conflicts of Interest, is another step in that direction. As I said, it's our 8th now, and this topic is one that comes up all the time for many of us. I've dealt with this in practice twice this week alone. In issues. So for the next 2 hours, our esteemed panel will take you through some hypotheticals that have been developed over the past many months, and there will be analysis and study of those hypotheticals that will provide you with an understanding of recognizing and deal with conflicts of interest in the profession. Judge Virginia Kendall of the United States District Court for the Northern District of Illinois is very active in the area of ethics, having served as a member of the Judicial Conference of the U.S. Codes of Conduct Committee. And before taking the bench 10 years ago, she served as a prosecutor for more than 10 years in the U.S. Attorney's Office. If you are a fan of baseball, she's in the midst of dealing with the issues surrounding the renovation of the Cubs Wrigley Field, so she knows all about that too, and you'll be reading about that soon, I'm sure, in the papers. Bruce Green is a longtime friend of mine. Professor Bruce Green is from Fordham Law School, where he directs the Lewis Stein Center for Legal Ethics. He's been very active over the years in this area with the American Bar Association activities generally, and with the section of litigation in particular. You can read more about both of their backgrounds on my firm's website, www.cliffordlaw.com. I want to thank you both for being here today, Judge and Bruce. We will proceed shortly. To learn more about this topic, various materials have been developed that are part of the handout that you've received both here in the room at Paul Law School and for the thousands on the internet, including an article that I wrote on this issue. The seminar is being taped, and the 2-hour program and the materials will be available for viewing on the website, not for CLE credit on the website, but they will later be there. Those in attendance today, both on the web and in person, will receive their CLE certificates within the next week. Those here today can receive them at the end of the program. Also, your questions of us are welcome throughout the program. The computers are being monitored, and we will do the best that we can to accommodate those listening on the web. We have over 3,500 people on the web at the moment. So I want to thank everyone for joining us through the magic of the technology that we have here today, and we'll get on to the first hypothetical. Once again, conflicts of interest. Don't blame the panel or me because we're throwing someone else under the bus. So when you don't like these names, know that the person who is responsible for these names is not here today. So, retired golfer Gary T. and his wealthy friend Max Moneybags decide to form a corporation to establish a golf-themed restaurant. Moneybags will provide the capital and T will run the operation. Moneybags asks his longtime business attorney, Larry Lawyer, to paper the deal and establish the corporation. 2 years later, after the restaurant becomes a huge success, but the business relationship sours, Moneybags muscles T out, taking advantage of an obscure clause in the incorporation papers. T retains new counsel, who files a disciplinary grievance against Larry Lawyer, and a lawsuit against both Larry Lawyer and Moneybags ensues. The allegations include that while Lawyer jointly represented the two business partners in the incorporation, Lawyer sold out T to serve the longtime wealthier client, Moneybags. So I think our first question, to Professor Green is, how do you handicap the grievance proceeding that has been initiated?
Well, I guess the key question is whether, in fact, the lawyer represented both T and Moneybags, because if he did, then he has problems. What's the problem? Well, when T and Moneybag were entering into this deal, they obviously both had different interests. There would presumably be issues about money and control and what happens if, as occurred, things go bad. And if they each had their own lawyer, presumably their individual lawyers would say to them, this is what you might want to do in order to maximize your interest, in order to ensure that if things go bad, you keep control, in order to best protect your money, etc. Whereas if you have Larry Lawyer representing them both, the risk is that Larry Lawyer will serve one well or the other well, but you can't maximize the interests of both. It's a zero-sum game. So, the question here will initially turn on whether Larry actually represented both of them or represented only one of them. And if Larry represented both of them, then the next question will be, A, can you do it at all? And B, if you do it, how do you do it? So I assume it's actually not all that uncommon for lawyers to represent business partners in creating a corporation or a partnership, etc. Or at least at one time it wasn't all that unusual. But you need to have informed consent because of the conflict of interest.
But let me interject. Larry Lawyer argued in his defense that, hey, I never owed T any loyalty. He argues that he never represented him and only Moneybags or the future corporation. And if I did represent T, it was only as an accommodation. Besides, my only responsibility was to paper the deal. Isn't he papering the deal for, he can say what he wants all day long about Moneybags and it's only the corporation, but he was papering the deal for both of the creators of the corporation, wasn't he?
So I think there probably was a time, maybe before you and I were practicing, when you could have made that argument. But what does it mean to paper the deal? Nowadays lawyers have clients. They have one client or two clients or more.
What about the obscure clause?
Let's talk. Well, let me finish about papering the deal. So the idea of papering the deal is what you nowadays call limiting the scope of the representation, which is a term in Rule 1.2 of the rules. And what it means is I'm not representing you fully the way a client would expect to be fully represented. I negotiate for you. I advise you. I craft the deal for you. It's I'm representing you with respect to some limited amount. So papering the deal would presumably mean you negotiate the terms. You guys figure out what you want. You come to me. You tell me exactly what you want, and I will put it in legalese. And if you're going to do that, although it creates risks, then you need the client's informed consent to that. One thing that in your recitation you didn't say, Bob, is, I papered the deal and I got the client's consent in writing, or even I got the client's consent. So if you're going to actually represent both of these guys, and just for purposes of papering the deal, they need to know it, because otherwise they're going to count on you to look out for their interests.
Well, but and that's really my point here. Whose obligation was it to say, I mean, this could happen any day right now. We have two guys one has the money and the capital, but it has no experience in running a restaurant. The other guy knows how to run restaurants and has no capital. The one guy has a lawyer by definition. He's a wealthy man with assets. And he gets his lawyer and he says, hey, we're going to be equal partners here, put this thing together. That, to me, smacks of a joint representation, that he's not one guy's lawyer over the other, and that he's a lawyer for the corporation and the two forming participants. Judge, what do you think?
On the web, Ian here is asking, can you represent both, as you touched on it, if you have a waiver of conflict agreement?
This is going to come in front of me in this big mess, and usually it will come in front of me with one of the lawyers standing there down the line saying, well, I represented the corporation at the time, and if I represented the corporation, my obligation was to make sure the corporation was fine. That's what they'll say to me. And then I'm going to start asking a lot of questions. Who retained you? Who actually had that very common sense factual question up front? Who went to whom and asked for the help to be given, and what kind of agreement did you have up front? Now, if one of those lawyers said, I'm hiring you to do this documentation, meaning create this contract for me, then you're going to have a big problem. And you can't just say you're representing a corporation if one individual originally hired you to do the work.
And in this example, of course, the corporation didn't exist.
It
when
didn't
the lawyer
even
began
exist.
The work. It was an unformed, unborn, nascent corporation.
Exactly.
So there are actually clever opinions that say you can represent the yet-to-be-born corporation if you do it in writing with clarity, et cetera. I mean, it's another variation on the informed consent idea. If everybody knows what you're doing and not doing and who you're doing it for and not doing it for, then you can do this.
Professor, in that same vein, you mentioned in your remarks Rule 1.2.
Right.
And pertaining to that limits the scope of representation to avoid conflicts. Is that right?
It lets you do it with informed consent. I mean, the trick to all of this is that the clients or non-clients really have to understand what your role as a lawyer is. And if they don't, then they're going to come back and say, and in a lawsuit before the judge for breach of fiduciary duty, they're going to say, I thought you were my lawyer, I thought you were looking out for me, and it turns out you didn't. You let me enter into this with this clause that allowed money bags to take over the company. And had you been looking out for me and not selling me out at the beginning, then you never would have let me sign this thing.
Yeah. So the question on the web was, all right, so now I've got a document that says that when the lawyer was hired by one of the individuals forming the corporation, the lawyer went and got informed consent, saying you recognize that I'm only representing the nascent corporation, not either lawyer. Are we fine?
That's my question for you. So, right?
The ruler, right? Who's going to make the determination?
Although I suppose it could also come from before a disciplinary committee.
It can, yes, right. And so the answer is that it's going to be driven significantly by the facts of exactly that. What's in the consent? What was conveyed? What was the representation? And I'm always going to be looking for, is each individual and the corporation having the best representation such that there isn't this conflict, this inherent conflict. We talk about conflicts of interest in such a legal sense, but really what it is, am I looking out for you? Do I have your best interest in mind? And when you start getting into the facts, when you start really working out, what if the corporation gives only 2 of the 3 members all of the wealth? No, then the third guy's not being watched out for. What if there is a burden on one that the others don't have? Then the lawyer that formed that corporation is clearly not taking into account each individual's best interests if there's no waiver. And I'm going to have a hearing on it. And it's going to be fact-intensive, and I'm going to make a determination based on those facts.
So let me ask you about this hearing. So let's suppose you have the most brilliantly written waiver in the world,
okay,
and it clearly waives all this. But Gary T. comes in and says, look, I didn't read this. It was just like a lot of paper. And I'm just a retired golfer. I'm not a lawyer. I didn't get it. How much of it is going to turn on not what's actually written, but what was actually understood?
I think a lot of what is written is going to be the primary. If that document is in there with signatures and no one's disavowing that signature, it's going to be very hard for someone to turn to me and say, I didn't read that. Plus, someone who's forming a corporation, I'm going to take into account his expertise in business. Maybe he is not a businessman.
And Professor, this goes to a point that I was going to ask you exactly. And so in terms of lessons learned from going the back and forth here, how does the bar, how should we best protect the clients, protect ourselves relative to the creation of this informed consent document? How do you take Gary T's remarks away from him, if you will? You know, because some would argue the remarks of convenience, saying, hey, I'm just a golfer, I didn't read the paperwork. How do you take that away from him? Do you have him sign every paragraph, a block at the next of every paragraph, affirming that he read it? Or what's the best way to protect yourself?
We also have a question from Pam that brings this up on the web that says, how important is it that there is a presumed different level of business sophistication?
Right. That's a factor. That's a factor. But that's definitely a factor. So now, if I've got my document that's all blocked out, I'm not a lawyer in a firm right now. So, do you want a signature on every paragraph? Do you want something else?
So I think Bob's exaggerating a little bit. So this is how I would have done it.
Not all the time.
Here.
I never do that.
Yeah,
Okay.
right.
I mean, the easiest thing here is if the lawyer says, I'm just going to represent money bags, because
Right.
then you don't have a conflict, and gets Gary T to sign something or send something to him saying, just so you understand, I don't represent you, I represent only money bags. If you want legal advice, get a lawyer.
Period. Very
That
easy.
costs the cost of a stamp.
Right. Right. And then we'll fight over whether he received the letter.
Again, I turned to, like, I made notes to myself about, okay, out of every one of these examples, what are the lessons that we learn? Is one of the lessons that we learn here to say to Gary T, look, yes, I'm going to do this, and yes, I'm going to deal with you in good faith, but the fact is, why don't we get you another lawyer? Do you have a lawyer? Recommend one of three, so that it can never be said that you weren't fairly advised here. I mean, is that the lesson here?
I think avoiding conflicts is going to be the lesson of this whole program, and what you've described is, avoid a conflict by representing just the one client to the extent you can. You won't be able to do it.
But we're all in a hurry. That's going to cause the deal to go over another couple of weeks.
And it's expensive, and he doesn't have money. Right? Blah blah blah. So but you can't have it both ways. He can have legal advice from somebody who's mainly loyal to Moneybags. Let's suppose Moneybags is paying. He's the longtime client. And now T comes along and enters his partnership. It's really like you're the insurer for the deal if you're the lawyer, because if it goes bad, then who's T going to sue?
Well, Stephen on the internet here is making a comment that putting aside the conflict of interest, does not Larry Lawyer have an independent obligation not to engage in fraud and not to assist a client in perpetrating a fraud?
Oh, so then now we're assuming that there's intent that
that's
this
that
was what he was
clause.
going.
Where'd that obscure clause come from?
Right. The obscure clause. Now we're looking at intent, mens rea, to create an obscure clause, which would be this safety glitch, which would give Moneybags the big payout, right? And that again will be something that will be litigated, and it will be litigated as to whether or not that was in fact fraudulent. Right?
Well, I mean, you couldn't avoid that with the best waiver in the world, because you're not allowed to sell out one of two clients, even if it's a consentable conflict and they consent. So if you could show that the lawyer, deliberately favored Moneybags by slipping this thing in, then I think the lawyer has a problem.
Let me interject too, just here for a moment. On the screen in the classroom, we have Model Rule 1.7 on the board, and for those of you online, it's also included in the materials on the web. And I did want to, before we go further, ask Professor, we talked about this at the beginning of our meeting today, the model rules, right? Here we are in the state of Illinois. I know the state of Illinois has adopted the rules of professional conduct. We hear about the code of professional conduct. We hear about the model rules. Okay, what governs what rules of conduct we're working under relative to ethics if we're from Indiana, Ohio, California,
Right.
New
So,
York?
so every state court has adopted its own version. So, there's the Illinois rules, New York rules, et cetera. They're almost all based on the ABA model rules, but with differences. So every state court adopts them with differences. But then the federal district courts don't all have the same rules either. Most of them have the rules of the state in which they're sitting. They just have a local rule that incorporates it by reference. Some of them, actually, Puerto Rico, I know, incorporates the ABA model rules. And Northern District has its own rules. Right?
They do. And then, depending on the litigation, just think if you're a federal court and you're in diversity, if you're talking about someone's obligation, you might actually be applying the ethical rules of the state, which either the contract had written within it, or that was agreed upon by the parties, or which is applied in the diversity context. So it's not a simple question.
Your Honor, silly question on my part,
Yes.
but have you seen it where it really matters?
I have, and I've had a situation where there was a piercing of the corporate veil case, and the different factors varied between the states. It wasn't a significant difference, and actually in the opinion that I wrote, I actually said either way, this is the way I'm coming out. So, but I did apply it for both ones because there was a greater standard with one state over the other, and there was a dispute as to which of the state's ethical rules applied. They're very, very close, but in something as unique as that, you're going to see changes, variations.
And if I'm pro hoc in Illinois, I'm
Right.
governed by your
You are.
rules
You're
rather than
governed by
my own.
mine, yes.
And all the most of the state rules have a choice of law provision for discipline purposes, but it doesn't necessarily govern what the courts are doing. So you could be subject to one set of rules for your own state discipline purposes and another for purposes of a disqualification motion or a civil lawsuit or
Right.
something like that.
I don't want to get, hold on one second. I don't want to get bogged down by too many questions, but I did see several here. The gentleman there, yes.
Thanks. So if you want to take on a joint representation, and
She's bringing you a mic, so we need you to do the mic so everyone can hear you online. Thank you.
so if you want to take on joint representation and use an informed consent waiver letter, how general can that letter be, or how specific must it be? Are there certain elements of the informed consent waiver document that you would insist upon or recommend in any circumstance?
So that's a great question. So the rule actually says if you look down to 1.7b 4, it requires each affected client gives informed consent confirmed in writing. So as far as the discipline rule is concerned, you could get the consent orally after 3 hours of discussion about all the implications and the risks and whatever, and then the letter confirming it could just say, this is to confirm that you've consented to the representation, notwithstanding the conflict of interest after I discussed it with you ad nauseum earlier today. You don't have to spell it all out in detail. So whether you do or not is actually sort of a strategic question. I think if it comes before the judge, I'm guessing, you could tell me, the judge is going to like it better the more detailed it is, because she's not going to credit your recollection that during the course of those 3 hours you put in all this stuff. But from a disciplinary point of view, it leaves it to you.
Well, Lonnie is asking online that even if there's a referring attorney and the choice is given, is it not fraught with the same dangers for the same reasons?
When she says referring attorney, meaning that somebody else came in and gave outside advice?
I think the line means that if an attorney then instead tries to refer to another attorney
Oh.
who they know,
Right.
it doesn't not have the same connections
Right.
and
Well,
the same conflict.
that's a good question too, because then now the question is, how did that referral occur, and whether I, for example, might pick this guy because he and I have a long-term relationship of referring clients, and maybe we're good golfers together, and maybe we have an interest that when I refer something to him, I know he's going to do what I want, right? He's going to do it the way that I want it done. And you know that happens out there, right?
Ooh, that shows a lot of paranoia about the bar. But the one thing I do know is that you can't get a referral fee for referring something
That's
to
right.
the opposing counsel.
Say that again?
You cannot get a referral fee if you have a conflict, and so you're referring out business.
Referring out to someone else.
To someone who's going to be negotiating
To
against you
negotiate,
or litigating against you.
But what about the bigger question about referring to someone that you know, just from your background, because you're buddies, is going to look out for your interest as the referring attorney?
Well, certainly on a referral of a case, I mean, different hypothetical, there has to be disclosure to the client. There has to be, the fees have to be reasonable. It has to be in writing. And, you know, I think that's 1.5E that we're talking about, and that has to, you know, be strictly complied with under current, certainly
Right.
Illinois
Well,
law.
if you could have a referral fee in this situation, then you'd have to do that. But I guess what we're talking about is, you know, you have a conflict. You can't represent both parties to the deal, so you suggest to one, why don't you hire, you know, one of these firms? I think that's pretty benign. You're not talking about a litigation. You're talking about the guy who you're, you know, going to be negotiating with. But, you know, I don't know what the local culture is.
Make it I'm not saying it's the local culture, but make it a prosecutor. And the prosecutor has a witness, and the witness has some criminal exposure. I'll tell you what, I'm going to refer you to a particular, you need a defense attorney in order to enter into this plea agreement with me. Let me refer you to one that I've worked with before, who I know is always someone who will plead out his clients rather than fight, right?
Did you do that?
Of course not.
Okay. But
It's actually a criminal case right now, pending, you know, in the courts. So that's the kind of thing where, when you're referring, it better be as open as the original
Well, staying on that
attention.
for a moment, and if that referral does occur, does Gary T have any argument whatsoever that Larry Lawyer, who did refer him out at least up to some point in time, and even now, has some kind of loyalty, equal loyalty and fiduciary duty to him?
I think the best argument would be against the lawyer he hired based on the referral. And the argument would be, you sold me out in order to keep getting referrals from your friend who was representing Moneybags. So maybe you don't want to accept the referral
Right.
in Chicago.
I mean, most referrals aren't like this. I mean, this isn't a situation. Most of the time, you call someone qualified within the area. Maybe someone can turn off the beeping over there. You call someone qualified in the area, you know that person, you respect that person, and you refer a case. That's very common. But it can come in as a factual scenario that referral was done for other reasons, especially if there's a long-term relationship that may have other factors.
Yeah. And by the way, we didn't write these hypotheticals to make it a simple yes and no,
exactly.
discourse, right?
Ethics is never
we're
that
looking for
way.
some. Yeah, we're looking for a little disagreement here. I saw a gentleman right there with his hand up.
Maybe on that note, what jumped out to me was T retains new counsel, and this is a big ethical problem, but the real tough ethical issue here that I see is T's new lawyer filed both a disciplinary complaint and a lawsuit at the
Right.
same time. That has so many permutations of ethical issues right there. That I
you
don't
put
know
in
if
file-
that's part of this hypothetical, but an attorney cannot use the ARDC process to gain an advantage in a civil matter, and he's done both at the same time. Is there any comments on how that should be handled? I know the rule technically says you cannot threaten, but that creates a whole open area where what is T's counsel actually doing here?
Right, okay, so
And
let's look at those two, the two parameters of that issue. Because on the one hand, he cannot use that threat to the ARDC to gain an advantage in his lawsuit. On the other hand, he has an obligation, right, to report the unethical conduct.
Bridging that dilemma.
Right.
I've never seen in an ethics seminar representatives from the bench, the ARDC,
Right.
or anyone ever really be able to give meaningful guidance
Well,
on that. Is it
well,
just a simple?
I'm only a representative
Right.
from a
Oh,
New
no,
York
no,
law
I'm being-
school, so
I-
I can't address
I'm
this.
saying is the rule
And I
as
certainly
simple
won't give a
as
preview of
just
coming
do
attractions.
it, don't threaten it.
That's what I would say. So I think this is absolutely unimpeachable what was done here, because if you said something like, I'm going to bring a lawsuit, if you don't settle it, I'm going to refer you to the disciplinary authorities, that would be threatening discipline in order to get advantage in a civil matter. But if you file it with the disciplinary authority, it's in their hands. It's not in your hands. There's nothing to threaten. And then you go do your lawsuit, and they proceed independently. The disciplinary agency might say it's too close a question for us. Work it out in the litigation process. The jury in the litigation might say, we're not persuaded, whatever. But they're two different processes, and there's two different interests at stake. One is protecting the public from lawyers who commit disciplinary violations. The other is compensation for the party who was injured by a lawyer. You can't, deal with, put the discipline on hold forever. I mean, that's not appropriate if you have a reportable obligation. So I don't see a problem with this at all. I don't think this runs afoul of the rule.
Steve, though, is asking, isn't the new lawyer taking a risk by even filing a disciplinary action, because by doing so, he's trying to gain an advantage in a civil matter, which in and of itself is unethical?
I think that's the answer that we just gave.
Yeah, we just gave it. And I think the conclusion was he's not. I mean, once it's filed, it's out of the hands of the lawyer. It's in the hands of the authorities, and they'll deal with it in due course. Okay, well, let's go on. We have more involving Mr. T. So in the same lawsuit, T versus Moneybags and Lawyer, Moneybags asked the corporation's general outside counsel, Chris Counsel, to serve as one of his attorneys in the litigation. When Chris Counsel, again, outside general counsel, files a notice of appearance, T moves to disqualify, arguing that, number one, as a half owner of the corporation, T must be treated as a client whom counsel may not oppose. Number two, counsel's role in the litigation would conflict with his role as corporate counsel. Number three, counsel is a potential witness in the litigation. Chris Counsel responds that he has never represented T personally. His role in the litigation is aligned with the corporation's interest, and he is not a necessary witness to the proceeding. Judge?
Judge is thinking number one, hearing, and the one that pops into my brain first is this person going to be essential for me to decide the facts? And the third one is the one that troubles me the most as the judge, because, and this has happened to me in court before. So a lawyer stands in front of me, and that lawyer is the person that's created the corporation or the entity that's in dispute, and there is a dispute regarding the representation or the role of the corporation or an act in the corporation, and that moment of incorporation is going to be at issue. And that person has to tell me about forming that corporation. And now I cannot have that person represent the corporation and be a witness. Fundamentally, in my courtroom is my issue, because I want someone who is representing the corporation to be able to put on her as a witness so that I don't have this inherent conflict. There are circumstances where I can, in my discretion, say that it's not to a critical issue, and it could be waived, but I would never do it until I also inform them, what if? And again, we're in one of those scenarios. What if it branches this way? What if it branches that way? And if it does that, and we have to decide that issue, and my witness is that incorporator, the one who drafted those documents, I can't get my hearing done.
So how quick are you going to be to pull the trigger on this? Because this is the beginning of a lawsuit. We don't know if this person has testimony about anything that's important, whether there aren't other witnesses, whether it won't be stipulated to, and importantly, whether it's favorable to or adverse to the corporation. Because the rule is if it's favorable to the corporation, then one of the person's law partners can do the case, and this person can be the witness. But if it's adverse to the corporation, then that's a problem for the whole firm. And what most judges, I think, are going to want to say, do depositions and come back later. Why should I have a hearing now? I have other things to do.
Wait a minute, though. As a member of the bar, where does it come to pass that I have an affirmative obligation up front when I'm being asked to get involved in this litigation in the capacity that we're assuming? Don't I have some duty to look at the rules, whether it's adversity to a former client, 1.9, conflicts of a concurrent representation, 1.7, the advocate witness rule, 3.7, imputed disqualification, 1.1. Don't I, at some juncture, under the issue of appearance of impropriety or something else, have a responsibility as a member of the bar to say up front, I can't do this, and as distinguished from creating a collateral issue that's going to have to be litigated in the proceedings, which can't be in anyone's best interest.
So Chris Counsel looked at this very closely, evidently, and there's competing interests.
Some would argue not.
If you get out of the representation every time counsel on the other side says you have a conflict, you're just giving the other side an instrument to deny your client the right to counsel of choice. So you have to make a good faith determination about whether you have a conflict, or it's on the line, or it's defensible, or it's just a bogus argument. So, here obviously you need more facts, but
Right.
He made a judgment that he never represented T. He's not adverse to the company, and he doesn't need to be a witness. Now, that may change as the plaintiff's theory changes in the case, but if you make that judgment early on, what do? I assume you present it to the client, because it's the client's call whether they want to get new counsel now, notwithstanding the risk that their lawyer will be later disqualified, or stick with the lawyer they've had for a long time and they trust, etc., and wait to see how it happens, and maybe have to fund litigation over disqualification. But I don't think I know you're just raising questions, that you necessarily, as soon as somebody says you have a conflict, you run right out of there.
Let me answer both yours and the professor's. In yours, I hope you're sitting there thinking when you're in the lawsuit situation, oh, this is a critical fact that I would really like to convey this to the judge. Where is the source of this information? It's me. That's the moment in time, right? I really want the judge to hear this critical piece of information. Who's going to give it to the judge? Me, as a witness. Then you want to go get somebody else on board. And to answer your question, when does it happen in a lawsuit? This is the judge answer. It depends. And it depends, in my piercing of the corporate veil lawsuit, right from the very get-go, you know that if you're trying to pierce the corporate veil to find out how corporations were formed, right, then the person, the corporate counsel who's coming in and formed them and representing that entity has a pretty good likelihood that she's going to be a witness, right? However, when does it come up in papers before me? Rule 56 statements for summary judgment, long after discovery is done, and I'm sitting there trying to decide whether there's a disputed issue of fact. And here comes the disputed issue of fact, and it comes in the form of something directly from the lawyer versus another fact. And now he's litigated the whole case, right, up to this moment in time. And then I have an obligation to raise it with them, and they hopefully will listen and tell me why I'm wrong about getting off the case. But that's what I'm going to listen to.
Well, listening to what Judge says, let's pull up Rule 3.7 pertaining to counsel and a witness in the same proceeding. Judge, isn't it certainly permissible for a lawyer to be a witness and also a counsel in the same proceeding?
It depends.
Okay.
It depends. If that is the critical witness and the credibility of that witness is the key to the determination of the case, you should not be a witness in that
Well,
manner.
is that unwise or impermissible?
Impermissible.
Okay.
You disagree?
No, I think it's incredibly rare, unless it's just like at the end of the case, a contested issue about your fees or something. The idea of first taking the stand and then summing up on your own credibility that's one role too many accepted at March.
Can you imagine, or asking the jury, now I was a very good witness when I was up there.
Right.
I really thought I did well.
But I want to ask you about one of the other conflicts. So your hypothetical, Bob, has a couple of conflicts in it, and this is one that the courts have dealt with in lots of different ways. So the argument is, look, ordinarily you're outside counsel for a corporation, you represent only the corporation, you don't represent constituents of the corporation by virtue of that. You don't represent the officers, you don't represent the board, you don't represent employees. But it's a corporation with two owners. It's a jointly held, two shareholders. And now one says, well, you were effectively my lawyer. It's true that we didn't have a retainer agreement, but I was going to you all the time, and I thought of you as my lawyer, which probably has some reality, right? I mean, I've never worked at a corporation, but if you're dealing with that lawyer all the time, you probably do represent, develop some kind of trust relationship, et cetera. But how would you rule in this? I know your answer is going to be more facts, right?
Right.
But it's a very fact-bound question, isn't it?
Right. And this does come up. It comes up it actually comes up in the criminal context too. It comes up in my courtroom when there is an attorney-client privilege asserted, right? And the attorney-client privilege that's being asserted is, well, this is my lawyer giving me this advice. I acted upon the advice of my lawyer, but the lawyer's really the lawyer for the corporation. Comes up in that context, and it's all so fact-based. But I also think you have to be aware that all of the different entities that we have percolating out there, we throw corporation, we have LLCs, we have S corporations, we have all these different kinds of animals in the corporate world, and a lot of that will depend on who represented them in what kind of formation they are, is from my perspective, because I'm looking also at things like diversity and role within each individual LLC member or something like that. There's going to be a different analysis for each corporate animal.
Daniels is asking, is there any difference if the parties already agreed to a bench trial where the attorney is acting as a witness?
It does make a big difference. It makes a big difference that I personally am able to set aside, for example, any problem between argument and fact. We assume I can do that. And so it does make a difference if it's a bench trial.
So
Bob Kramer is saying hello to the professor and hello to Bob Clifford, and is asking, though, that did not the Northern District of Illinois, though, drop its unique set of ethics rules that it adopted in the early 1990s and go with the ABA model?
We went with
now?
the ABA model rules. Yeah, we went with the ABA model.
But not with the Illinois state.
Right, but remember, again, we're diversity courts. If we're sitting in diversity jurisdiction, you may be applying another state depending upon the issues, and especially if it's a contract. And we're kind of starting our discussion on a contract discussion.
Judge, on the same note, not to deviate too much, but I wanted to ask you in that same vein. There's a restatement out there of law pertaining to ethics. Could you tell us about that and where it comes into play in both in the courtroom and in practice in your experience?
Okay, so the rules of conduct of Illinois are law for Illinois lawyers. The case law of the state is law, over the federal court is law in federal cases. The restatement is drafted by the American Law Institute in order to both guide the development of the law and give some guidance to lawyers. So it's really secondary literature. It's not really law anywhere. And in fact, on issues where the law of the different states is in conflict, the ALI adopts what it regards as the best result, even if only 5 out of 50 states have it. So you can't really count on it as an actual restatement of what existing law is. But that said, courts do cite it, like other authority, like treatises.
Okay, thank you. Any questions?
Just a comment that what about with respect to consent? Judge Posner's position is that if a party to a business transaction doesn't read the contract, it's their hard luck.
Right. Well, that's one of those facts. Remember early on in the case where we said if the person is sitting there and he's just the golfer who doesn't know anything, and I have that document that shows his signature and all of that language in there, that's going to be a significant factor. He said, what's most important to you? That kind of waiver form.
But on this one, I don't think it's true of lawyer-client contracts. And so the law of lawyer-client contracts has never been treating them as people with equal bargaining position, equal knowledge, et cetera. And so if you were trying to rely on client's consent and you never did it orally and it was only in writing and you never made sure the client actually wrote it and it was fine print, et cetera, I think you lose, at least as a disciplinary matter. I don't know what a judge will do, in a case, but informed consent puts the onus on the lawyer to make sure that the client actually understands, not that just there's a writing somewhere.
So I think if we look at this hypothetical and we talk about lessons learned, there's 2 of them that come to mind for me, and one is, sounds like it's just generally unwise to seek to hire the corporation's counsel to handle a claim about a disputed control issue within the corporation. It's filled with peril. And then the second is it's something that I'm reminded of when I was a law clerk back in 1974. There was a well-known lawyer here in Chicago, Emmett Galvin, and his son and I were classmates, and Mr. Galvin one day said to me, he said, Bob, when things go bad, everybody's working on a handshake and a smile, but the first thing they do when it goes bad is that they look at the paper that it's written on. So I think that's the moral of the story here. Those contracts matter, and I, for one, believe that when in doubt, if there's any appearance that there could be a conflict, the lawyer's got to find a way to address that openly and with transparency and get the right kind of authorizations to proceed. Otherwise, it's just you're setting yourself up for an ethics beef and a dispute that maybe clients shouldn't have, and it could be costly to them. Let me turn to hypothetical number 3. We'll get away from this golfer and his ne'er-do-well partner, and we'll talk about Susie Snake. So again, Susie Snake defends a game manufacturer, Cubes and Blocks, and she's the CEO and its CEO in a sexual harassment lawsuit brought by a former employee, Bonnie Bipp. In his deposition, where do we come up with these names? Tim
I didn't write
Touch.
them.
Not us.
Well, I know who it was. I just don't want to throw him or her under the bus. Okay, let me start. Susie Snake defends a game manufacturer, Cubes and Blocks, and its CEO in a sexual harassment lawsuit brought by a former employee, Bonnie Bipp. In his deposition, Tom Touch denies ever bothering Bonnie and swears that their relationship was purely professional. Thereafter, the plaintiff subpoenas Tom's former secretary, Hannah Hurt, to a deposition. Susie offers to represent Hannah at the deposition in Hannah's official capacity and invites Hannah to a preparation session. Hannah says that she recalls seeing some emails from Tom to Bonnie that seemed to reflect a romantic involvement between Tom and Bonnie, including one that said something like, "Thanks for the great night. You are everything to me, but don't tell my wife." So, Professor, how should we proceed? Is there a conflict of interest there for Susie Snake?
Yeah.
And while you're talking about that, I want to know about a violation of, if any, of solicitation rules that Susie reached out and wanted to represent Hannah in this deposition.
Okay, so let me take those one at a time. So the conflict issue. So the Snake owes loyalty to the company and to its CEO, who I assume is Touch here, and her job is to try to make the case go away, ideally by showing that Touch did not harass the plaintiff, did not touch the plaintiff. And now here's Hannah, who's being deposed, and she has an interest as a person being deposed, which is basically in not committing perjury. That's her main interest, which means she wants a lawyer who's going to help her understand the process and help her get her recollection straight and help her not lie. I don't think a lawyer who's representing the defendant can represent the deponent at the same time in this situation.
Wait a minute, it's done every day. These lawyers that were defending corporations say, hey, you want to subpoena our former employee. In fact, we have a right to represent that former employee. We have a right to contact that former employee. And if you contact that former employee directly, we're going to accuse you of an ethical violation.
But here, as we've learned, the former employee, the current employee, has a recollection that's quite adverse to that of the client, of the defendants. And so what would you do if you were an independent lawyer representing her alone? You would basically say, tell the truth and let the chips fall where they may. If you're representing the defendants, you're going to want to influence her recollection, hopefully in an ethical way, but even so, to be as helpful as possible to your client, regardless of the truth. And that creates a conflict, I think. And so what happens every day in cases doesn't mean, in most cases, the witnesses are just witnesses, and their testimony is consistent with the position of the client corporation, but that's not the case here. So I think this is different.
I think you really have to listen to that statement. It happens every day, so must be fine. That is probably the most terrifying ethical reason for doing anything. Everybody else is doing it, right? If you're a corporate lawyer, corporate counsel, as you know, this is probably one of the hairiest ones when it comes to these internal investigations and criminal investigations, and this is just a civil case. So this one is hairy enough. Then throw in the potential that there's a subpoena popped on people and the relationship to the CEO. That's from my old life. And it's really complicated, and it's not something that you're going to take lightly. You are going to really think through, is the statement, is the due diligence, have I done my due diligence to determine whether this statement is a statement of someone that is adverse to my client, the corporation? Is it in my understanding from what I know that I cannot represent this person and that this person should have someone else represent them? And that's complicated stuff.
Before we get to the solicitation point, also, what do you think about the idea of saying, I'm not representing Hannah, I'm representing her in her official capacity?
Oh, yeah. Are you asking me that?
Yeah.
Right.
What do you think about that?
I don't think it works. It's just like saying everybody else is doing it that way, and so I've somehow used some magic words that will shield me from responsibility. The conflict exists whether or not you are talking to her in official capacity or not. I'm not sure how we're separating her role with your client in her official capacity, since I assume that this personal activity was occurring while she was in her official capacity.
I think the concept is, I don't actually represent her, I represent the corporation, and since the corporation acts through its employees, including Hannah, she's not my client. So when I'm giving her advice, it's not for her personal benefit, it's for the corporation's benefit. But she's going to think it's for her benefit.
That's right. Well, that's the big risk here, and that's the big risk for all of you who are in corporate counsel positions when it comes to these investigations. That's the big risk. And there's just a whole body of law out there that you would need to review to make sure you're protecting the interests of your client first, and then not to stomp on the other witnesses' rights as well.
So Dean is asking here.
Before you get to the solicitation, though, Professor, and maybe in your remarks to you and Judge, would you throw in there at some juncture, is there a distinction between Susie Snake's representation of the corporation versus her representation of the CEO versus her representation of the witness? Hannah.
Well, the CEO and the corporation, I'm assuming, are going to be aligned when they are making decisions and discussions regarding business decisions of the corporation. When the CEO is operating outside of that capacity, and this is going to come again to me in the form of an attorney-client privilege, right?
But what happens when Susie hears, I did not have sex with that woman?
So don't you think, I mean, even the representation of the company and the CEO in this case is probably perilous, if not improper, because the company, if it turns out, contrary to what it assumes at the beginning, that he actually did have sex with that woman, it's going to want to throw him to the wolves.
Right, because we want to save the corporation. Right.
Well,
exactly.
Dean is asking along those lines, isn't the problem that Snake will have to cross-examine Hannah using confidential information learned as her attorney?
That's true, too.
Yeah, there's a lot of problems here.
How about the solicitation one?
So it's interesting. In my state, there's actually a case which I think is a blight on the jurisprudence that says that it said in the case where the company's lawyer offered to represent company employees, that was improper solicitation. I mean, and technically, sort of, it looks like that under the rule, because the rule says, at least in my state, something like you can't have in-person or telephonic outreach to someone in order to offer your services for money. But, what really happens is the corporation asks you to do it. You're reaching out to them on behalf of the corporation. The corporation's going to pay. Probably what should happen is first you reach out to them in their role as a witness and you say, I want to talk to you and find out what you know, because you can't make the decision to represent them until you know what they say, because depending on what they say, you might have a conflict of interest. And certainly you can reach out to them, unless they're personally represented, as a prospective witness in order to learn what they want to say. So I think the solicitation thing is weird, but I do say if you ever come to New York, you have to worry about that.
Going back to Susie Snake, and in the course of her discussions in preparation for this deposition, Tom Touch confides in her that you know what, there might be something to these allegations. What are Susie Snake's obligations there, Professor, with regard to can she continue to represent the CEO? Can she go forward with this deposition? Who is her duty of loyalty to, and who's her fiduciary duty to in terms of her responsibilities as a lawyer?
One problem here is they've already done the deposition of Tom. He said, I had no sexual relations.
Right.
And now, if she actually knows that that's true because Tom has admitted he did have sexual relations, or because there's some other source of information that gives him actual knowledge, then the first thing you have to do is figure out, do I have a duty under Rule 3.3? I don't know if we have that one.
We do. We should.
Correct. So the 3.3A3 says if a lawyer, the lawyer's client or witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonably remedial measures, including, if necessary, disclosure to the tribunal. So if your client or your witness has lied in the deposition, you can't ignore it. If you know of it, you have to do something about it. So the question here is, I guess, does the lawyer have knowledge? Who's the source of the information?
Him himself.
Is it Tom
Him
himself?
himself.
So
Judge
I
himself.
think when your client says, I lied, I really did have sexual relations with that woman, you can take that to the bank. I think that is actual knowledge for purposes of the rule, unless he's sort of psychotic or something.
And then the question is, though, so now you're representing the corporation, and the corporation, let's assume that the corporation is a small corporation, so that a lawsuit, if found to be accurate, may result in millions of dollars, right? Then do you have a conflict here as far as, well, forget the money. I mean, we won't make the conflict based on a certain amount of money, but isn't there a conflict between your representation of him and the corporation?
Well, you certainly had the conflict. If you didn't have the conflict at the beginning, you have it
Right.
now. But I don't think you could solve your 3.3 problem by
Right.
withdrawing, at least not by putting the facts, giving the facts to the next lawyer, because it would be so easy to say, well, I know the rule says I have to take reasonable remedial measures, and the only thing that will remedy this is if I tell the other side. But I'll avoid that by withdrawing.
Well, withdrawing from representation of touch.
Bring up 3.7.
Well,
So what if you say, I'm going to stay on board with the corporation? Now you have some
okay.
information that's damaging. My corporation is my client, and boy, a $2 million lawsuit against my client is really going to take him down. I think you better get somebody else to represent you.
right. I mean, what you'd really like to do, and in the old days might have thought you could do, is settle the case. Right, and make it go away. But that provision about reasonable remedial measures, that does not include settling on the cheap. The other side, if you settle now, will settle based on the assumption that this is the testimony that Tom is going to give. Maybe it's true. It's a disputed issue of fact, blah, blah, blah. That would be, if not a fraudulent settlement, certainly one that the ethics rules don't allow. I think so at some point, whether before you get out of the conflict or after or whatever, you have to remedy this.
And so I brought up 3.7, get a lawyer as a witness. When Tom, tells Susie what he does,
Right.
does she all of a sudden become a witness?
I think it's privileged.
Well, but whose privilege is it? Is it his, or is it the corporation's? Or that goes back to who does she represent?
Who does she represent
Right.
at that moment in time? The remedial measures, what is a reasonable remedial measure is a great question. I have actually had it play out in my courtroom in such an extreme moment that I respected the attorney for doing it, but my goodness, had his client on the witness stand, and she was telling a story, and it started to get very, very creative, and then a little bit more creative, and then one of those, wow, really? Creative? And then the lawyer asked for a break, spoke to his client at sidebar, and then came to me and said at that moment in time, Judge, I cannot continue direct examining this witness because of the rules, my ethical rules, and may I ask your permission to allow her to testify without me leading her, giving her questions.
Is this a criminal case?
It was a criminal
Okay.
case. So, I mean, you can see that's like the real big remedial measure in a criminal matter, suborning perjury. He knew that wasn't true at that moment in time, and so he did that amazing remedial measure right there.
Gentleman in the front row.
In the criminal cases, you can do the narrative approach. You can't in the civil case, but you are supposed to remedy it in the least harmful way. I suppose here, what you could do is say, what could you say? We withdraw the deposition testimony of the
I'm not
witness?
sure.
How do you do it?
I'm not sure what the remedial measure is.
Or we suggest that
I
you don't
see.
rely on the following pages of his deposition.
I don't know if you can do that because, of course, if you're the opposing counsel, you want that information to,
You want
look
blood.
at it. Right? I don't know. That's a very good question.
Yes, sir. In the audience.
What if the corporation is undergoing an audit this time and the normal auditor's inquiries are going out to the lawyer with the inquiry about do you know of anything that can result in loss or do you know if there are any illegal activity?
Right.
And you don't really have the option of just merely not answering the question because that raises further inquiry. It seems you've got to come up with some kind of response to that.
So this is a subject for another panel, but
It is.
because it really gets to the question of whether the lawyer for the corporation can waive the privilege essentially and answer the auditor's questions. I think the litigator who's in this case is not going to be waiving privilege and disclosing stuff learned in the course of the lawsuit. But
I don't
Well, we'll take
we'll save the next year's program.
next year's.
Yeah.
Okay, writing that down. So we'll take one more
It's a good complicated
question on
one.
this topic from the web, and then we'll go on to our next
We do
hypothetical.
have, several questions on the web.
Put them
but,
together.
Well, someone asked this, Joe asked, if Snake tells Hannah to tell the truth and let the chips fall where they may, is there anything ethically wrong vis-a-vis the corporation to do so?
Well, that's why there's a conflict, because if you're the corporation, you might feel that wasn't very good lawyering on our behalf. You should have probed her recollection. I mean, it gets to the question of how do you prepare witnesses for deposition. Obviously, the answer is you don't suborn perjury. But I think there's a range of what people do with witnesses whose recollections may be inconsistent with what you know from other sources or think you know, et cetera. And so I don't think that as a legal or grievance matter, the corporation can complain. But you still have the conflict problem.
And Mary asks, does the corporation have an obligation to pay for an attorney to represent Hannah when she's deposed concerning the issue?
I don't know the answer to that. Does any corporate lawyer know the answer to that? I don't know.
Okay.
Manny?
I
For
don't.
next year.
I believe they do.
I don't know the answer to that.
Manny Sanchez.
Danny Sanchez
Pinch
says
opinion up.
he believes they do.
There you go.
Now we get
That's
credit
for
being
purposes
truly
of everyone on the
interactive.
web.
We didn't even answer. Here, come on up.
All right, so we're gonna leave Susie and her problems behind and turn to those of Johnny James. Johnny James is a family law practitioner, and he's long represented the socially prominent No Good family. Norbert No Good, a ne'er-do-well family member, tells Johnny that he is engaged to Wanda Wealthy, a nouveau riche widow. Wanda wants Norbert to sign a prenuptial agreement drafted by her business lawyer. Johnny, and a lot of that's playing out right now in Chicago. I think.
Sure.
Johnny encourages Norbert to schedule an appointment and bring Wanda along. At the meeting, Johnny welcomes Wanda to the family and says that he is pleased to add her to his clientele, which includes 4 no-good generations. Johnny then explains that the marriage will proceed much more happily if the agreement is slightly revised to give Norbert half of Wanda's substantial estate in the event of her death. Johnny produces a new agreement, which Wanda reluctantly signs. A half year later, despite Johnny's best intentions, the marriage hits the rocks and Wanda seeks to rescind the prenuptial agreement. Professor, who had a conflict there?
Johnny James.
And how'd that come about?
But before we actually get to that, first of all, she had a lawyer in this situation, right? She had a business lawyer. So he violated the no contact rule. I don't know if that's on your list of, there you go.
There you
Yeah,
Press.
4.2.
Okay, so you can't communicate with somebody when you're representing a client. You can't communicate with somebody on the other side who's represented by their own lawyer. You have to go through the lawyer, not around the lawyer's back. So that was problem number one. And then basically prying her away from her lawyer and representing her in a situation where there's an obvious conflict because it's in Norbert No Good's interest to get as much of her money as possible. It's maybe in her interest to not give it to him. And how can you represent both of them on a prenuptial agreement? That doesn't make sense at all.
And then he hustled the case. He solicited the
Right.
client.
Yeah,
7.3.
that was the least of his problems.
Judge, how would you handle this in the litigation that might ensue?
It's pretty simple. Why is it always simpler when it's a personal situation like this, where it's obvious that there's conflicts between the interests of the two individuals? It's obvious she was represented. It's obvious that he reached out to her. So it seems so much more direct. And yet if I change those all to corporate entities, we'd probably be scratching our heads more. Isn't it interesting? When it's personal, we tend to be able to understand that conflict better. So maybe that's a little cue for you as to how you might think about them when you're determining whether you have a conflict.
So you probably don't get a lot of matrimonial
I don't,
cases, I'm
not
guessing.
even-
But
no.
but you know, it's an interesting question. I mean, it's one thing to say he gets punished or he gets sued.
Oh, no,
But
it's another
what-
thing to
but-
say.
But do you rescind the
Right.
agreement? I mean, two adults who sign this thing and a
Right.
deal's a deal, and
Right.
why should Norbert be punished because his lawyer screwed up?
But
Sue
wait
the
a
lawyer.
minute. What's wrong with the argument that, well, two things I want to bring up. First is, going back to the duty of the bar. I mean, I think a lawyer in first-year law school, Mr. Haskins right there, could tell you that this is a conflict. Okay?
Even
What's
Mr.
the-
Haskins.
What's the duty? Is it? And what's the duty of the lawyer in that circumstance to say to his client, the family, the no-good family, I can't do this. It's a problem.
4 generations of no goods is enough.
And so that's number one. And number two, isn't there an issue about just presumptively undue influence that goes to Your Honor's point about, adults reading the paper and interfering with it? When all of those things occur, isn't it a presumptive document that should be void? Because of the clear violations of the
I
ethical
thought we were
rules?
doing an ethics issue and not a contract issue. Because if we're doing a contract CLE, I spent my morning doing that with the Cubs, so we're going to not go into that.
If you void it, then Norbert sues the lawyer.
Right.
If you don't void
If you
it,
don't
then
void
Wanda
it.
sues the lawyer.
Exactly.
Either
Right.
way, he
Right.
gets sued.
Right.
Well, let's talk
So I mean, so contractually, it's going to. My point being, you're going to look at it from contract terms. You're going to look at it from the agreement. You're going to look at what is there, and then these issues will come in a different way. And ethically, it's going to play out differently potentially than legally as far as the contract is concerned.
Well, let's go back then. There was a right way for Johnny to do this, wasn't there?
Right.
Under 4.2, let's talk about that. Isn't there, what should Johnny lawyer have done, mindful of the fact that there's a business lawyer involved?
Well,
Contact the
he
business
could have called up the business lawyer and said, "This is what I want." Of course, he would have never gotten the great deal of half the estate. So we can assume probably nefarious intent in that regard, right? He knows that person exists.
Okay, there we go.
You're underestimating
I
the
know.
power of love.
Exactly.
So now, turning to now that Wanda knows she has this dilemma on her hands, she hires a new lawyer,
Right.
Betsy Beast. Betsy files suit to rescind the prenuptial agreement. Johnny represents Norbert in the motion to rescind the prenuptial, and Betsy files a motion to disqualify Johnny. The judge denies the motion to disqualify.
How could you do
What
that?
was she thinking?
What was I thinking?
So, going back, Professor, Rules 3.7, rules
Right.
lawyer as a witness again, Rule 1.9, conflict with former client. What's 1.9?
Yeah, let's talk about that. So the rule, I don't know if you want to put it on the board, but
It's on the
is
board.
basically you cannot represent a client against a former client in the same matter in which you represent the former client or a substantially related matter. So here, Johnny represented Wanda stupidly with respect to drafting the prenup.
Right.
And now he's litigating against her with respect to the same subject matter, substantially related, meaning the prenup. He's adverse to her own client. The point of the rule is mostly to protect client confidence, is a little bit to protect loyalty. The idea is, you learn things in confidence from a client. You shouldn't be litigating against them in a situation where you can use those confidence. But here, of course, if there were confidences, they were shared, right? So there's not really a problem in this situation Maybe that's why you denied the motion.
I don't know why I denied the motion. It must have been bad morning.
but he's still a potential witness.
Absolutely.
I think.
I mean,
So-
this judge probably would not have denied that motion. And again, going back to that issue, which was our earlier one, that this is a very real situation where he could be a witness. A real situation where if we're going to sit down and get into the nitty-gritty of the formation of this and allow in any kind of parole evidence to determine that contract, now he's in a very real situation of being
But the interesting thing is just because he's not disqualified doesn't mean he doesn't get disciplined, right? Because the disciplinary authorities may see this differently from the way the judge did. Maybe the judge said, well, because of the exigencies here, I'm not going to disqualify because, it would be hurting Norbert too much. He's already sunk so much money into this lawyer. But that doesn't mean, Norbert doesn't get his license yanked or suspended or something.
Questions from the web?
We do. And Howard is asking, generally, when you do discover a conflict of interest, what are your duties? Do you have a right to be paid and repaid for any costs even that you've advanced?
Are you talking about the client have the right to be repaid, I assume?
No, the lawyer.
Does
He
the
was a
lawyer?
the lawyer
Has the right to be paid.
Well, you need to know the facts of the conflicts, but generally, they're the lawyer's fault, not the client's fault. And so the lawyer's fees are a little bit at risk. So if you're a client and you have to hire a new lawyer and get that new lawyer up to speed, and it costs you more than it would have been if you just hired the new lawyer in the first place, I think the lawyer who had the conflict that created the problem has a financial risk. So there's another problem with having conflicts.
We have a question from Bert who's saying that if a lawyer is at a large law firm and advises a relative in a pending case, and then a case is brought against relatives to this last hypothetical, is brought against a spouse of a long-standing client of the large law firm, can the lawyer at the large law firm continue to advise or represent the relative, even though the case may adversely affect the spouse as a side issue?
I can follow that. If you want to answer it, you can. Otherwise, I think we should go back to Bob's hypos.
We'll
send
with
an
our
email.
hypos.
If you could simplify that, we'll give it one more try. No?
Well, I think what Bert here is asking is that when you're involved at a large law firm, the lawyer at a firm could have access to the spouse's legal documents and computer storage, and so therefore, is it really realistic that you could be setting up a Chinese wall or not?
We haven't talked yet, and we'll get later, I think,
Yeah.
to imputed conflicts, among partners. So why don't we hold that?
Okay.
There's one in the back, though, Bob. If you want. There's a question
I'm
there.
sorry, thank you. Yes, sir.
Who has a duty to report this conflict? The judge knows about it, the opposing attorney knows about it. Should there be a rush to the ARDC by all the people involved saying, Johnny really violated the rules?
So I don't know if you want to put 8.3 on the board.
Yeah.
So
Okay.
lawyers, if they know about serious disciplinary violations, I'm paraphrasing now, by other lawyers, and judges also have a similar rule, they have to report to the disciplinary authority. Illinois is famous for the Himmel case,
Right.
which sanctioned a lawyer publicly for not following the reporting obligation. So I don't know, I think you only need one person to report, but somebody here, if they know, has to report. Now, often in conflicts, you're talking about things that are debatable. So it may be that nobody knows that there was a disciplinary violation because it was a litigable issue.
Well, I think that's the very point. And by the way, for those of you on the web, ARDC is the Illinois Attorney Registration and Disciplinary Commission. All of our states have some form of the lawyer police. And I think, at least from what I know about them and how they'd handle a situation like this, and to the professor's point, it may well be a fact question. And that's why they have an investigative, capacity to get to the facts, and then their panels reach the decisions that they do, and they go on from there. So not everything is as black as white as we're trying to make it today, I guess.
And in the severe cases where the judge makes a determination that there's an ethical violation and it's in the opinion, it's a cover letter in the opinion off to the ARDC. That's the way it works.
So, Judge, can I just, as a side, it seems to me that if the ARDC gets a letter from an aggrieved client or an aggrieved client's lawyer. Take the gentleman's point. So now we have he writes the letter. He's the new lawyer. And instead, the letter comes from, Virginia Kendall, United States District Court judge. I mean, is there any experience you have or observation anecdotally about, wow, one letter is going to be put on the pile and the other one's going to
and my letter isn't saying, this person did, it's just please see attached, and then the opinion is there. It's a public opinion, and it can go out for them to take, determination as to whether that needs to be done. I've never talked to Wendy or to Grogan or to any of the others at the IRDC to say, well, we really listen to you when you send us something. But of course, when I send an opinion, it's going to be an opinion on a summary judgment or a bench trial, right, or a hearing, and then I'm going to have made a determination of conflict. I have had situations where I've had an attorney who has been in front of me who clearly was not well due to substance problems, and the transcript was clear on its face from the discussion, and I will send it over to the ARDC with, this occurred in my courtroom this morning, to let them know that this is not someone who can be representing clients, and maybe I had taken him off the case. I think he was recruited, and I took him off the case based upon the misconduct. I mean, we have an obligation to preserve the integrity of the people that appear before us, is the way I look at it. I don't look at it as a narc or as in any way like my old life as a federal prosecutor. I look at it as there is a human being out there that was also victimized, being the client of that lawyer who, in fact, in that case, the statute of limitations ran due to this individual who was representing her.
So if I were the lawyer and I said to you, Judge, allow me to self-report, and I'll CC you.
Oh, I've never had that.
Because that's what I would recommend.
Yeah, I've
because
never
I
had
think
anyone do that.
It would take a little bit of the sting out of it.
Right.
Okay, one more. Manny?
Do you have an obligation in a situation where you're duty bound in Illinois by Himmel to report, and this just happened today, so I'm asking, do I have an obligation to let the lawyer that I'm going to report know? Now, I'm not using it for an advantage, but I am going to report his misconduct. Do I have an obligation to let that lawyer know that I'm going to do that, or can I just proceed with the ARDC and do that?
I don't think so. Now, the lawyer gets a notification
afterwards, right?
After the letter. So
I think you'd be well advised not to do that,
Right.
lest you be accused.
That's what I assumed you were going to say. I wanted to confirm
almost
that.
going back to your question, which is, by informing him I'm going to report you, it makes it sound more like you're using it in an aggressive fashion, right? But I do think it's important to note what the professor said about these gray areas. Himmel does require reporting, but a conflict of interest where someone might be coming on or off a case and making those decisions, that is one area of ethical violation, and very different from someone who is incapable of representing a client due to substance abuse or who has really violated one of the ethical rules in such an egregious way. And if you have one of those situations, stealing money from the attorney-client trust fund, right? You have that in front of you. I think that's really, it's a no-brainer. It's an obligation for you to preserve the integrity of what you all do to just do the one cover letter. And you don't have to be a snitch and say, this is what happened and this is how it happened. You've got a record. Get a transcript, send it, get a letter, send it, and then it's up to them to make that call as to how egregious that violation was. That's not our call, that's their call.
Okay. Well, as we're going to see now, Mr. Johnny and his client Norbert are still up to their dirty tricks. So here we go. Hypothetical 6. Having inherited millions of dollars and remarried, Norbert No-Good asked his family lawyer, Johnny James, to draft mirror wills for him and his new wife, Lucy. Norbert, I can't even pronounce that name.
I don't know, Lucretia maybe? I don't know.
I tried.
Lucretia. Right.
Lucretia, okay.
That's
Lucy.
good.
Her friends call her Lucy, okay.
Lucy.
Norbert says that the children from his first 3 marriages, who are among Johnny's current clients, sure, of course, will receive the paltry sum of $500 and a tongue lashing for never calling Norbert on his birthday. Norbert says that the bulk of his estate will be divided between Lucy and, quote, all of his children, end quote, who include 2 children with Lucy so far, and a child born out of wedlock of whom Lucy is and must remain unaware. As requested, Johnny drafts the mirror wills. Nothing Johnny wouldn't do. Naming himself as executor, and Norbert and Lucy happily execute them thereafter. Professor, why shouldn't Johnny be getting his ticket punched here?
Okay. So I don't think I can defend him.
Okay.
So can I say why I wouldn't?
Yes, please do.
Okay. So there's actually two problems here. The big problem is he's representing Lucy. She's doing her will as well. It's a mirror will. As a general rule, lawyers have to tell their clients things that the clients need to know that's relevant to the representation. One of the things she needs to know is that if she signs a mirror will, she's giving some of her money to a child that she doesn't know about, who was born out of wedlock. If she knew that, she might say, fine with me, but she might also say, no, I don't want to sign this will. Now, there's a problem for the lawyer. Either he knows the information in confidence, in which case he has a conflict because he has a duty to keep confidential for Norbert, something he has a duty to tell Lucy, or he doesn't know it in confidence, in which case he has to tell her. But either way, then she'll have a different set of interests from Norbert because she may not want to do mirror wills, and he'll have a conflict. So I don't think he can do the mirror wills. I think once he knows that information, he has to get out of the representation. The other issue, which I think is an issue but the ABA doesn't, is so here he's representing all these people who he's disinheriting, right? Norbert is disinheriting these 3 children. The lawyer represents the children as well because he represents 4 generations of this family. Wouldn't you think that it was disloyal if your lawyer was drafting your father's will and writing you out of it? Wouldn't you think that was a betrayal? That was an act of disloyalty? The ABA says no.
Because who's the client? Go ahead.
What's that?
Go ahead.
Yeah, I mean,
That's
right.
why the ABA says no.
Why does it say no?
Yeah, because the client is not the heir.
But the lawyer also separately represents the children, right? I mean, you can't represent Norbert suing a current client. You can't represent Norbert in a deal with a current client.
I brought up
without consent.
1.4 in terms of communications and disclosure obligations. Is there anything there in 1.4 that helps us with this?
No.
No. Okay. Well, thanks a lot.
No.
Well, and what
brought it
about,
up.
but what about the fact that he's also the executor of the will? All right, does that bother you? He drafted the will,
there's
and
another one.
he's an executor.
Can you name yourself as executor in a will?
Lawyers do it all the time, don't
do
they?
I don't know, estate
Yeah.
people?
Estate, who's the
Remember,
estate?
don't listen to that as the ethical
Yeah.
parameter. Lawyers do it all the time.
You like that one?
I do like that one.
Well, I know you can't name yourself as a beneficiary of the will.
Right.
That creates a...
Right.
Well, Johnny could.
Unless you're a family,
Right,
unless you're a
Johnny.
family member. Well, you can if you're a family member, and if he gets himself adopted by Norbert.
That's right. Maybe he could put that in there. Throw some adoption papers in.
Well, wouldn't that be an impermissible gift then, 1.8? You know?
Are you going to put that one on the board?
Sure.
Okay.
There's a method to the madness here. Come on.
Just went the
1.8.
other way, 1.8.
Okay.
So what would you do, though, Bob, if now you know that about the illegitimate child, but you've been representing this family forever, and you don't want to lose them as a client? Do you just withdraw from representing Lucy? Would that solve the problem?
Well, isn't that 1.16? Isn't that what it says you're supposed to do?
Well, presumably Norbert said don't tell Lucy, so you have to keep his confidence. That seems.
And this goes back to what I've said to you repeatedly today. At what point in time doesn't the member of the noble profession have an independent obligation to say, hey, there's this rule 1.16, terminating representation. And it kind of talks about how I really ought to back out of this case under some circumstances.
Okay.
Well, back out of representing Lucy,
Right.
right? But you're going to stay on board for the family. You're going
Presumably.
to hold on to that privileged communication, which is there's an illegitimate child out there, and my client said don't ever tell anybody.
See, but Judge, this goes to what, again, I'm trying to drive this issue because I think it's really important for the practicing bar. And that is, doesn't there come a point in time when we lawyers have to be introspective, reflect upon what's going on? We take a test on these rules, and say to ourselves, there are some issues here that I need to address. And it goes to one of the gentleman's questions earlier, whose duty is it to get into this and make these things happen? And I say, it's, there are issues for the bar here to address. And apparently, Professor, you think it should wait until the judge gets involved.
No.
No, you don't be a physician, but what's your experience been?
I would say the point of this exercise is to show exactly why you want to deal with this at the earliest opportunity, because you don't want a lawsuit, discipline, loss of fees, and all, loss to your reputation, etc. But the truth is, in this situation, lawyers who do estate work do represent families. They don't, often, and these things come up infrequently. And so generally, if you're doing estate work, you assume married couples, their interests are aligned, they want to do mirror wills, etc. So part of it is, in the other situations, you really could recognize at the outset. Here, notwithstanding that Johnny James, we know from past hypos, is an idiot, representing family members in estate work is not inherently a conflict, and you just have to be sensitive to when these issues arise.
2 points. First is, then we'll go to Leslie, the question. Many firms solve this problem by having a counsel to the firm that they go to when they have these kind of questions. Okay. We dealt with this yesterday in the office. There was a conflict question that we had. We call our lawyer and get advice from our lawyer. And for those firms that don't have a lawyer, whether it's Chicago Bar, Illinois State Bar, even ABA, as I recall, there are, and then the Illinois State Bar as well, they have committees that you can go to and seek advice. And I really think it's important for the bar to recognize that. And when you have that, you want to be proactive, seek out those resources.
And I just want you all to recognize that it isn't just a lawyer thing. The committee that Bob talked about that I served on for 6 years with the judiciary is called the Judicial Codes of Conduct Committee. And I was the representative for the Seventh Circuit. That is an ethics position where we have a code of conduct for our conflicts, and we analyze them as you appear in front of us, and you can make a motion to recuse based upon our code of conduct. And that is such an active committee. Just so you understand that when I served for the Seventh Circuit, it was common for me to get between 3 and 10 phone calls per week from members of my colleagues saying, what about this? Am I allowed to go speak with Bob Clifford at a continuing legal education seminar at DePaul University? Am I allowed to accept an award? Am I allowed to stay on this case if my wife's brother is the CEO of this company? Every single day of the week it's going on. And we have that same procedure within the judiciary because ethical issues just permeate our practice. And they percolate up, and it's not beneath any of us on the judicial bench to go out and ask questions. So don't feel that it's beneath you to go and seek out the same resources.
And for those who want to do legal research, there is a whole body of literature out there. The bars issue opinions interpreting the rules. There's treatises. There's the restatement, which you pointed out, but there's I have no stake in any of this, but there's lots of treatises and lots of writings, and so if you want to figure it out yourself, that's also an option.
First, we have one question in-house, and then we'll go to the web. Leslie?
I was just going to point out in this hypothetical, Lucy is the wife number 4.
Right.
So when you're talking about getting out as quickly as possible, if you're going to get out, that is a fact that I would consider in this
you
case.
think 3 wives ago?
Well, no, in this case, but to do mirror wills in a situation like when there are 3 predecessor wives would be a good factor to consider quickly. You'd realize that right away.
Okay. On the web.
Well, from the web, yes, a lot of questions. Denise brings up the point that Rule 8.3 requires reporting of dishonest or criminal conduct, but that a conflict does not necessarily mean that a person is being dishonest. Which
do you want to? So it says you have to report knowledge of a violation that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. And so the question is, which violations does that include or exclude? So there's, the literature suggests, highly technical things, a very technical conflict, is not going to be included. But not all conflicts, I think, are excluded from that definition. They might not raise questions of honesty, but trustworthiness or whatever. The other thing I think what we should point out is, so C says, but you don't report if your information is protected by Rule 1.6, which is the confidentiality rule. In our hypos, I don't think it would have been because it was all stuff that happened in court.
I think it all happened.
Yeah.
Well, we had the one information that was provided. Oh, no, it was in a deposition.
Yeah.
So it was all in court.
Well, and Jeff asks here, does Johnny have an affirmative obligation to tell Lucy about the child born out of wedlock, or only truthfully answer her questions if she asks?
Well, that's inherent in the conflict. If he was representing both, then his duty would be to both. That's kind of what shows the conflict. That's why the issue that Bob said is get off. You need to get off so that you don't have that conflict.
It's actually a really complicated question about, how do you deal with confidences between co-clients?
Yeah.
Usually, for the privilege purpose, the assumption is that they're shared, but they may or may not be. And even if they are, what happens when one client says, look, I know we're sharing information, but here's something I need to tell you in confidence. I have a child by another woman. Is now the original sharing deal, all bets are off? Or does that supersede the, I need to tell you this in confidence? Very complicated.
Very complicated.
Complicated stuff. Okay, one more question from the web.
Well,
There's no answer if that's what you're. He wants the answer. You can't get an answer to a lot of these. We're walking you through the process to consider so that you'll be prepared too. It's all so fact laden.
there's also a question, how is Lucy even harmed here? If her will is a mirror of her husband, would that not include her illegitimate child?
It was his
Well, she wants to decide whether to sign that will or not. Right.
Okay.
Or-
But that is actually, on that very point, and it was a question that popped in my mind earlier when in the discussion. And where does the notion of proximate cause, if you will, come into play with all these violations, if any? So that is to say, what's no harm, no foul? We use that phrase a lot around here. No harm, no foul. Come on, what's your big problem?
So when I was on the ABA Ethics Committee, and I drafted an opinion, and I had in this sentence, no harm, no foul is not a principle of legal ethics. And then they made me take it out. But it's true. It is not a principle of legal ethics.
Everybody's doing it. It's also not a principle.
We got two going here. Okay.
Judges will say when they ask me a question, sometimes they'll say, well, I know I saw Judge so-and-so do that last year. And I always say, don't look to your other colleagues either. So it happens all over.
All right.
Jason says that beer helps to frame then resolve the ethical rift.
So say that again?
What?
Jason says beer helps to frame then resolve the ethical
comic
rift.
interlude.
All right.
I'm sure he's referring to the
All right,
case.
we're leaving Johnny. We're leaving Johnny alone. I don't know that there's anything good we're going to learn from Johnny
All right.
anymore. Okay, well, let's talk about Carl. Carl Cookie, a general practitioner, has represented Robbie Rich. Guess how he got that way? For many years on various business matters and considers Robbie a friend. Carl just represented Robbie in the sale of a business that netted Robbie several $1 million in profits. Carl needs a loan to rehab his kitchen and would rather pay interest to Robbie than to a bank. Carl asked Robbie for a $25,000 loan to be repaid at 10% interest. They do the deal on a handshake, and Robbie writes a check. Professor, how many violations of disciplinary occurred there?
A good
So
rule on
why
this.
don't we put 1.8 on the board?
Okay.
So
It's
there's
1.8.
actually a rule, 1.8, that deals with business dealings, 1.8a, business dealings between a lawyer and the lawyer's client. And what it pretty much does is it codifies common law opinions. So in cases, we could talk about how the court might view this, where lawyers are trying to enforce business deals with clients. There's been a lot of case law going back lots of years. And the basic principle is these are really frowned upon. So if you want to take away in advance, it's really don't do a business deal with a client. Either have them as a client for your law practice or do business deals with them, but don't do both. But in any event, the rule itself is not as prohibitive as common sense might be.
But in fairness, wait a minute. Okay. So, because I know of people who have done stuff like
Okay,
this.
so if you're going to do
done
it,
properly.
if you're going to do it, here's what you do. You need a lot of writing. So first of all, the transaction and terms have to be fair and reasonable. So it's not, it can't be you're in arm's length, you're the shark exploiting, sort of like Shark Tank or whatever. It has to be a fair and reasonable deal. And then the terms have to be in writing in a manner understandable by the client. So that's number one. Number two, the client has to be advised that it would be a good idea to get your own lawyer and be given an opportunity to do that, and that has to be in writing. And three, you need the client's informed consent in writing to the essential terms of the transaction, including whether the lawyer is representing the client in the transaction. And by the way, can a lawyer represent the client in the transaction? Because then don't you have a conflict between your own self-interest in driving the best bargain and the client's interest in getting disinterested advice about the terms of the deal? Now here, at least if it's 2015, 10% sounds pretty good. Right?
Well, that's why I'm saying it's not a bad deal for Robbie.
Right. Maybe the lawyer needs a lawyer.
There we go. Judge, any takes on this one? Have you had
I
anything
think
about
that this is a situation, too, where I think it's unrealistic for us to think that lawyers and clients don't develop, especially business clients, don't develop good relationships where they really trust each other and the work, so that there may come a point where you might want to do something like this. But I think, as you said, documenting it is everything, and really the icing on the cake to make it work would be to say, have someone else represent the client in that deal. And that would just be the appropriate thing to do. Yeah. But whatever deal that is, now you have to think in future, is this deal that I'm making, is it in any way going to impact my representation of my client and everything else that I am doing?
Well, let's find out about that, because Robbie and Carl saw past all these issues, and then the next thing we know, that Robbie, in hypothetical at number 8, is, while representing Robbie in the sale of a business, Carl charged a flat fee of $5,000. Inasmuch as the sale of the business netted several $million for Robbie, Carl decides to have a heart-to-heart with him. Robbie, he says, I did such a great job for you negotiating the sale price of your business. It's in your discretion, of course, to decide to pay me some extra fees. Whatever you think is fair. Robbie decides to give Carl a check for $9,500 and an equal amount of cash. A month later, Robbie is mad and asks for the money back. Carl says he won't give it back. He never said it was a fee, and he views it as a gift. Robbie sues Carl. The case lands in front of Judge Julie Just. So, Professor, what does Judge Just decide?
I think you should be asking the judge.
She'll weigh in.
Okay. Okay. So this is the first question is, what is the money? So if the lawyer is saying it's a gift, then that kicks you to 1.8c, which says a lawyer shall not solicit any substantial gift from a client, et cetera, unless the lawyer is related to the client. Which, again, this is why you should adopt all of your clients or vice versa. I think it's just a gift is not a very good defense since the lawyer solicited it. Now, whether or not it has implications in terms of you have to give the money back or it's just a disciplinary problem is a different question. But if I were the lawyer, I wouldn't say it's a gift. I would say it's a bonus. I did a really great work on this. There's nothing. Some lawyers have in their retainer agreements, but you'll pay me X per hour or X percentage or whatever it is, and I retain the right to ask for a bonus.
Well, but that wasn't done here. So here's the real question. Even though Robbie is, this obviously very successful business person, he's also, a really nice guy who, doesn't want to, turn Carl away. He knows about Carl's problems in life, and he doesn't think Carl deserves anything, but Robbie's now asking. Can a lawyer really ask at the end of the transaction, absent something such as you just described, for more money because I did a good job? Can I orally ask for an enhanced fee because of a bonus, even though I don't have it in my upfront contract? Can I really do that? Isn't there something wrong about that?
See, you're baiting me.
I am.
Because when you say that, it makes me instinctively want to say it's okay. So that rule would be 1.5. I don't know if we actually have that, but you don't need it. It's just the fee rule, which says you can't charge an unreasonable fee. So, first of all, the ordinary idea is you have to tell the client in advance what your fee is going to be. So you certainly couldn't say, as a matter of right, even though I was billing you a flat $5,000, we agreed to that up front, I demand another $19,000 or whatever the amount is. You can't do that. But is there something wrong with saying, it turned out that this work was a lot harder than either of us ever imagined, and I got a result that was far greater than any of us ever imagined, and although you're not entitled to pay me more, you're certainly allowed to pay me more by way of a bonus, and we have this long-term relationship, and you're not obligated to pay it. But if you'd like to pay it, I'd certainly like to accept it. So you think there's something wrong with that?
But how then does the lawyer protect herself in that circumstance?
Right.
What do you do then? We get out the typewriter and start typing this up, and
Type it up as a bonus. Or
Actually, yes, exactly right. I mean,
type it up as a bonus, saying exactly what you said.
Right, yeah.
This litigation. I don't know. This is completely outside of anything I've seen, but I guess you could document it, right, and say, just like you said, it was beyond the pale from what I expected, and so.
Now you can't. One thing you definitely can't do
Sounds uncomfortable.
is say to the client before the representation's over, we're about to finish this deal, and it looks like I've getting a better result than you ever imagined. I'd like to renegotiate, and because you can't, that would be viewed as coercive to renegotiate the fee mid-representation. And while the ABA has an opinion on this, in some situations you could do it. It's the courts presumptively view it as overreaching. But I don't. But a bonus is different. You finish the work. The client's not coerced.
Okay. Questions on the web, and then we'll go to the web first, and then to the lady, and then the gentleman.
Well, this is an unrelated question, so if you want to.
Well, let's say unrelated questions for the moment.
Right.
Who's got the mic right now?
Just real quickly, that was a very good point about, give me extra, it worked out better. But in one area that does work its way into federal court a lot are federal tax disputes. And there's whole bodies of other ethical rules, IRS and other federal agencies on the charging of contingent fees. And the idea of, I did a good job on your case, now pay me more, could create a whole ethical issue.
I just think if you have a fee arrangement up front, and then at the very end of the case there's going to be some kind of discussion about extra money, it makes me uncomfortable. But I think we could probably create back scenarios that would be supported.
Professor, and going to the judge's point about feeling uncomfortable, wouldn't the lawyer be well advised, if not required, to say, look, I'm now asking you for fundamentally double the contract. Maybe we should get another lawyer to give you some advice.
You could do that.
Yeah,
that certainly would make it less assailable,
right.
I think.
Yeah.
What I want to see is the case where the lawyer says, I did much less work than I ever imagined, and this result is terrible. Please take back your fee.
All right.
If the lawyer has a history of doing that, then I'd be more sympathetic.
There you go.
I was going to add the comment that we haven't brought in statutory or rule provisions under local court rules that do allow enhancement or in certain intricate situations, including IRS. U.S. Tax Court now allows greater fees if you can prove certain elements. Personal injury attorneys now can go in and ask for a greater percentage under a contingency if there are certain things in place under statute in Illinois.
Right, but being permitted to do it and then having it agreed upon with the client, I think, is the situation here. The way we set up, well, I didn't write the fact pattern, but the way that it's set up, we've also got $9,500 in cash going over. I mean, that should make everybody a little bit nervous, right? And just think of it in a again, it'll be the way I look at things, facts in the law, facts in the law. The facts are going to be, what was the billing? What was the agreement? If every single time billing records look one way and they look the same way for month after month after month after month, and then boom, here comes $20,000 in the door and there's a line item that says bonus, good job. It's interesting, right? It's different. And then that brings you into court saying, I never agreed to that. That's really where we're at.
We have a case in New York that's been going on for a long time. It may be over now, where the lawyers renegotiated the terms in a way that ended up being favorable in the millions, and also got a gift that was like $1 million
And how did
gift.
it play out?
I think that our high court upheld the change in the fee structure. I think the gift might have been struck down. But so I was about to say, look, over $19,000 if the client wanted the money back, I would just give it back to avoid the disciplinary issues in the lawsuit. But then I remembered this, multi-million-dollar case, and I thought, well maybe it's worth litigating.
Right?
Which is quick, I just think this is very perilous if we don't have the rules that allow some increase in the fee or some other procedure. And I can imagine 3 months later, when you call it, whatever you call it, a bonus or whatever you want to call it, it's still extra money above a flat fee. And then you've got the situation where there's a falling out, and 3 months later, then you're in front of a disciplinary commission because the giver of the gift decides that was a bad idea. I just think it's very perilous for
And
lawyers.
I think the lawyer has, the optics here are awful. I mean, think this through. $9,500 in cash. So a lawyer's going to take that cash, put it into the bank.
Right
It's
below
right.
the
He
reporting
knows or
requirement.
she knows it's right below the $10,000 number.
Reporting requirement. That's
So
the
it's
old
not
federal
gonna be
prosecutor in
reported.
me.
Okay. I mean, there's just so many problems with this, and again, I think lawyers can be their own worst enemy. We've got to set it up to, if you're going to read about it in the newspaper, you want it to be something that your mother will not get mad at you about. So, all right.
Why do you always get to take the high road?
Because I'm the moderator. Okay. All right, now we're back to Larry Lawyer, though. We can't get the guy out of our hair. So Larry Lawyer, Hypo 9, represents the school board of Northridge High, on which Larry is also a member. A very common circumstance. A teacher, Morton Messup, has been arrested for possessing child pornography, and the school board asked for Larry's advice about how to respond, given that Messup is, quote, innocent until proven guilty, end quote. Before the board meeting, Larry learns that Paul Partner, a partner of his firm, was hired by Messup to spearhead his defense. Larry advises the school board to seek advice from a different attorney regarding the Messup matter. Nonetheless, the prosecutor moves to disqualify the partner, asserting that Larry's duty of loyalty to the school board in other matters creates a conflict of interest that is imputed to the partner. I think we were talking about this earlier,
We were.
Professor. What do you think? May Larry give advice to the school board in this situation? Can they have this so-called, I don't know why they call it a Chinese wall, why don't we call it an Irish wall?
Yeah, we actually call it ethical screens.
Ethical
nowadays.
screens
Right,
now.
Ethical
right.
screens.
Okay.
And the Irish walls are just those little stone, little
Okay.
I'm Irish. I can say that, right?
Right, we could see.
So should we start with whether Larry can represent the board and
Yes.
give advice to it while the
Yeah.
partner's representing Mesa?
Yes.
Okay. So this gets us to the issue of imputed disqualification. So here's the basic principle within a law firm or law office. All for one, one for all. So if the way you have to look at this is, partner is representing Mesa. Could partner also give advice to the school board? Would that create a conflict? Would it be consentable? If it would be impermissible for partner to do both representations, then it would be impermissible for somebody else at the firm to do both. So here, I would say I don't think you could represent the school board and the individual because, the school board is going to want to probably fire him. Mm-hmm. And if it does, if you advise the school board to do that, then Messup's going to think that's disloyal. And on the other hand, from Messup's point of view, he's going to want you to advise the school board, to keep him on and not to cooperate with the prosecutors and things like that. And if you do that, it's not going to be giving disinterested advice to the school board. So I would assume that one lawyer couldn't do both. And so I don't think two lawyers could do both. And then you raise the question, well, what about a screen? Well, the problem is, screens work when you don't need them, actually. When you have a consentable conflict, it's a way to deal with the problem. But, there is a presumption that confidences are shared within a firm, that all the lawyers of the firm owe loyalty to all the clients of the firm. So the screen would be okay if you could do this with client consent, in which case the clients might be more willing to give consent if you created a screen. But I wonder, do you think this is consentable?
No, I
think so.
don't. And here in a consent situation, too, as far as the firm is concerned, it sounds like the now alleged defendant has been represented by the firm longer than he's been representing the board. It just seems like a long-term client, or let's assume he was, and that's going to be one of the interests that the firm is going to take into account. I can tell you where I see this every day of the week when I recruit one of you to come on a pro se case. And then the first thing I get is I get a letter that says, oh, Judge, I have a conflict of interest because my firm represents the city of Chicago in this area, and this is a person on a 1983 case suing a city of Chicago police officer. Or I get somebody suing Northwestern Memorial Hospital, and they say, sorry, Judge, my firm represents Northwestern Memorial. When they want to get off a case, there is no question that they don't consider it consentable. They don't make any effort to make it consentable. So I'm assuming that it is something that inherently best to be off
But
of.
Judge, wait a second.
Okay.
I've got a Sixth Amendment right to counsel. The
Yes, you
only
do.
guy in the world that's going to get me off of this thing is that man right there. I need him as my lawyer.
Right,
You're taking my lawyer away from me.
which is why the conflict can't be fixed, because that's why Mr. Partner, right?
Yeah.
Paul Partner
That's who
represents
they-
him.
Yeah, they want to disqualify my lawyer,
Right.
who's Larry's partner, and the two of them aren't even on the same floor.
Okay, so first of all, so let's suppose Larry, lawyer, says, I represent the school board, but I'm not going to represent them on this matter. Well, they'll get separate.
Okay, that's
now
right.
does that solve the problem?
Not to me, and I'll tell you why. Because, of course, the exposure for the school board in a case of a teacher who's been potentially charged with criminal liability is significant, right? So, I mean, what did the school board know at the time? Did they screen the person when they hired? I mean, imagine the potential liability for the school. So I don't see, it seems such an inherent conflict. I don't see how you could consent.
So I'm Mess Up's lawyer, and I say, look, I understand the theoretical problem, which is that
Mess Up is my child pornographer. Okay.
Right. I represent the child pornographer. Other people in my firm represent the school board. The school board has interests. It has potential liability, whatever. I've never done any work for the school board. I don't care about the school board. I don't care about whether we lose the school board as a client. I am, as you know, Judge, the most zealous criminal defense lawyer in this town. I'm going to do a great job. It's a purely theoretical conflict. My client has a Sixth Amendment right to counsel of choice. You have discretion here, right? It's not governed by the conflict rules, and in any event, it would be a consentable conflict.
Are
under
you
the rules.
partner? Are you partner right now, representing Mess Up?
Yeah, I'm partner. I'm representing Mess Up. Some other lawyers in my firm represent the school board in unrelated stuff. They're not representing the school board in this. I'm going to just be a pure defense lawyer in this case.
Right.
And then the reason why the prosecutor is moving to disqualify me is because I'm a great defense lawyer and they want Mess Up to get some schmo, right? Why would you disqualify me?
Right. Well, that's the way Bob set it up as a disqualification.
Right.
I'm assuming that the school board moved to disqualify you. And Bob's correct when you're talking about the Sixth Amendment right to counsel. And there are some cases that talk about your choice of counsel, especially with the long-term representation. That's going to trump the representation of the other partners in your firm who represent the school board. So that's going to be a situation where I'm going to determine whether there's an inherent conflict. Do you think there is? Imagine all the documents and records about the criminal activity are going to be within the control of the school, right?
And then this speaks to, I think, and many firms have it. Not for the small practitioner, it's harder, I think. But a lot of firms have conflicts checks, right? So in other words, Larry's been on the board for a long time. We know that. The partner obviously just got hired because this just came about. Didn't that partner have a duty to everyone to do a conflicts check in the firm to see if he could take on this case?
Right.
And he would have learned that Larry's on the school board
Right.
and might be adverse. I mean, those are the kind of issues that ought to be examined up front.
And I actually put a wrinkle in the facts that aren't in there, which is an interesting question for someone in a firm like you, which is what if Larry is represented by the partner on all these other matters, right, and then he gets the criminal charge. So he says, partner, represent me on this, I want you.
Mess Up is represented.
mess up the criminal defendant. So that's more of an interesting question for you. So there was no conflict until the moment in time that he was charged criminally. So maybe they ran their conflicts check. School board is represented by your firm. So is mess up on other matters. But now he's going to be represented in the criminal case. Yeah. What do you do in a firm? What do you do with that?
I call that.
You call that guy.
I call that guy. Where's my guy?
And Adam on the web is asking, should Larry's firm deny representation to both the school board and the teacher, or just to refuse to represent the teacher?
Right, and I think that's the question I'm kind of punting over to a firm person to say, what came first?
Which representation
came first?
Our view would be that the second representation could not take place.
Right.
No.
Then also, Sherry's asking, if a firm can't represent both an employee and the school district, then how can a firm represent, for example, a truck driver charged with criminal violations and the truck driving company who fired the driver?
So typically in that, there are conflicts sometimes in those cases, but typically the way they begin is the company says, we're going to indemnify the truck driver.
Exactly.
And so our interests are aligned. It also happens, by the way.
That's a good point.
Yeah.
You're saying that because the company's agreed to indemnify the truck driver, that eliminates the conflict?
No, not in all cases, but I think it makes it a consentable conflict in most cases.
To me, I think that this is an unmissed point for the tort bar. Happens all the time. And yet nothing along the lines that we're talking about ever happens. Where the plaintiff's lawyer would come in, move to disqualify Mr. Sanchez's firm because he's got the driver and the company, and they clearly have some adverse issues, but that happens all the time.
The other place where this comes up a lot is when there's a suit against the prison guard and the state
police.
or
It's
the
every day
police
in
in
my
the
life,
city
right?
or whatever.
The city makes a call and they decide, is the conduct within the conduct that would be the qualified immunity type conduct that was within the course of his official duties, and therefore we will represent this police officer and indemnify, or is the conduct such that this person needs individual representation such that maybe his actions are outside of the scope of what we would naturally indemnify. I know I've got a corporation counsel in here, so maybe I'm saying it the right way or not. You can probably correct me what the decision is.
Question in the back.
Thank you very much. It seems to me that if partner stays on the case, the first thing that's going to happen is Larry's going to have to disqualify himself from ruling in the matter when the school board takes any vote.
Right.
But even before that, it seems to me we're missing the first conflict. I don't know how Larry can represent the school board if he's a member, because then Larry's giving advice. When Larry embezzles from the school board, and then the board says, well, should we take any action against you? He says, well, of course not.
This is an interesting issue.
My advice is not to harm me.
So there are a lot of bar opinions about can a lawyer or the lawyer's firm represent a company and be on the board of the company, and I think it's the same principle here. And basically the cases say, you can't give advice as to things when that you have personal interest in, but it doesn't prohibit you categorically from serving on the board of a company that you represent.
Okay.
Yeah, but I think I see a disagreement over here, Bob. If you want to.
All right. Well, we've got 5 more minutes. Time for one more question from the audience. I'm sorry. Apologies.
The point that I would make there is that the analogy of the corporations really is invalid. School boards are elected positions that are governmental that brings
not on today's program.
Yeah, that was the point I was going to make, because they can't serve with compensation here.
There we go. Okay.
Okay. So school boards are different.
We've gone through 9.
We've now
we've gone
exceeded
through
the
9,
limits of my knowledge.
9 hypos. We're going to make it through 10. We're almost at the bewitching hour. So you have some urgent question? All right. No. Okay. Hypothetical 10. Your client, Danny Do It Again, has fathered a child out of wedlock with Samantha Silly. You agreed to assist Samantha in pursuing the paternity case and collecting back due child support from Danny. She pays you a retainer of $5,000, and you agree to take a contingency fee on the back due support. You meet Danny in court. he asked you to represent him in an action to remove Baby Do It Again from Illinois to his now home state of Florida. He offers to pay you $10,000, probably in cash, to handle that matter on his behalf. I mean, Professor, how could that lawyer...
Even I can't defend this one.
Yeah.
So there's a basic principle that at least without client consent, you can't sue a current client. So you can't represent Samantha in seeking child support from Danny if Danny's a current client, at least without Danny's consent. And then having represented her, you can't ditch her. And besides, I don't think you could do any of this on a contingent fee basis because you can't have contingency fees
Isn't there a thing,
in domestic relations
Isn't there a
cases.
thing called hot potato doctrine?
Well, that's why you can't drop a client as a general matter in order to sue that client. So yeah, there's a lot of problems with this.
And there's a lot of follow-up at 1.9, if we could, to duties to a former client. Would, again, put aside the cash issue and the contingency issue, wouldn't the lawyer's duties to his former client really prevent him from getting involved with Danny?
Right. So see, first he represents Samantha in
Right.
child support, and then he represents Danny against Samantha in the removal case, which is undoubtedly related. And so leaving aside the hot potato issue under 1.9,
Okay.
you'd be adverse to a former client in a related matter.
Question from the web.
A separate issue, a lawyer agrees to be paid for creating a corporation with stock from for a new business. Can the lawyer make future independent decisions on behalf of the corporation while having a personal investment in this company?
So you want to take this? Or
No,
should I?
I mean,
Okay.
he's invested
All right.
in it.
So this would be what's called a potential personal interest conflict. So if you have an interest in a company that you represent, first of all, I don't want to say everyone does it, but a lot of Silicon Valley firms certainly do it. There's nothing categorically wrong with taking stock in a company. It may be a business transaction with the client, and so you have to satisfy 1.8A, which we talked about. But the question is then, going forward, if you have an investment interest in the company that you represent, the question is whether the things you're doing for the company are going to be affected by your interest. And so the company's entitled to disinterested advice, for example, maybe because you have an investment and you want to get out of it quick. That's going to affect the advice you give. It may be, at minimum, a conflict that requires consent. If it's going to really adversely affect your advice, then maybe not consentable. Maybe the client needs to get separate counsel at that point. But a lot of law firms, will do incorporations and other things for companies that don't have money at the beginning for an investment interest.
Well, Judge and Professor Green, we're at that point in the program when I have to start the wrap up, and I always end the wrap up by saying, do each of you have, if you had one thing out of this whole process, one message that you'd like to give to the bar on this issue, what would it be other than everybody does it and no harm, no
Right.
foul?
Don't follow everybody does
Yeah.
it.
Okay.
My one piece of advice would just be to ask. Every firm has someone, if it's a bigger firm, and those places that we mentioned have places where you can ask for advice. If you actually read, and I do, the reports from the ARDC at the end of the year, you will see that it's rarely a majority of cases where lawyers are being sanctioned because of really unethical conduct that they intentionally entered into, but rather negligently, stupidly, foolishly entered into that got them into trouble. And if you read those, you realize, wow, just a phone call would have helped me. So lawyers aren't very good at seeking advice for themselves. Get legal advice for yourself.
Thank you. Professor?
I think that it's seeing the issue. I mean, obviously, if you're representing multiple clients, you see the issue, but you may not recognize that somebody may perceive you as a client. Your conflict checking system may not kick back that you're being adverse to a current client or former client. I think once you see the issue, lawyers are presumptively qualified to get the right answers, either figure it out themselves or get advice or whatever. But it's often the failure to spot the issue because of the conflict check or whatever that does lawyers in. So I think it's being sensitive to the problem.
Well, two great pieces of advice. My sincere thanks to Judge Virginia Kendall and Professor Bruce Green. I think we've seen from today's program and discussion that discourse among us as an organized profession is the way we learn, the way we grow. Thank you for attending. Sorry if we missed your questions. We did the best we could, and we'll see you next year. Thank you very much.
Thank you for attending today's program, The Ethics of Conflicts of Interest by Clifford Law Offices. Please be sure to fill out and submit the evaluation form that can be found by clicking on the Handouts Print Capability tab. Certificates of attendance will be emailed within the next week. If you are attending in person here at DePaul, please be sure to pick up your certificate of attendance at the conclusion of the program just outside this room. And please be sure to sign the attendance record on the table outside of the room here to receive your proper credit. Please take a moment also to fill out the evaluation form and return to the check-in desk outside of room 8005 here. On behalf of all of us here at Clifford Law Offices, we thank you for attending. Good evening.